okayfm 101.7.
Honorable Alhaji Inusah Fuseini, a former MP for Tamale Central. Na yene no yenye legal education kakra ho. Honorable Memochi.
Mejo so me na apom de say.
Boko na wo so e.
Me ho ye.
As it stands now, say mean can say parliament is in limbo. One, as in the approval or otherwise of the president's nominee. Speaker give my reasons be say honorable Dafiamako at the Akwadan court. So pending the outcome of the the Akwadan Supreme Court, no, want me approve or my joining even sitting secret time on beba. Now I'm paying so no me who crate be Attorney General Minister of Justice Ora Godfred Yebo Adame and so at the Akwadan actually come speaker. Na mamin kan kakra bi na we dey inti say decision to halt the approval of ministerial nominees presented to Parliament in light of suit number Wakotu by Honorable Nelson Dafiamako versus Speaker of Parliament and then Attorney General. They were jointly sued until they all can
the defendant.
Defendant. Yeah. Or say in furtherance of my role under Article 88 of the Constitution and bearing constitutional responsibility for the conduct and the defense of all civil proceedings against the state, including Parliament, I'm constrained to draw your attention to some observations made from a study of the suit in question and the results of a formal search conducted at the registry of the Supreme Court today, 21st March 2024. 1. The action filed by Mr. Dafiamako, Member of Parliament for South Dai, consists of a bare writ of summons. No statement of case in support of the writ has been filed as mandated by the Supreme Court Rules 1996 CI 16. It is thus correct to say, respectfully, that the suit is not properly consisted in accordance with Rule 46.3 of CI 16. Such an action will be struck out where a statement of case in support of the plaintiff's writ is not filed within 14 days. Sir, what did he say here? Counsel, I was saying.
Oh, you see, checkmate. You know, when there's a checkmate, when you have to determine your next move. Now, there's a checkmate now between the executive and the Parliament. And so what the Attorney General is doing is trying to determine the next move that can be made to ensure that checkmate, free. If you want, if you don't get the checkmate, it's like a stalemate. And everything has come to a stop because of developments there every. But I'm surprised that Attorney General I'm a Parliament. Because Parliament as an institution is not an extension of the executive. Attorney General.
I was saying on the ejina or minor when it comes to BBI, including Parliament.
Yeah, but including Parliament. But he's not an advisor to Parliament. He's not a legal advisor to Parliament. He's a legal advisor to government.
Me too, pa.
So Parliament, the doctrine of separation of powers is important in matters of this nature. And that doctrine of separation of powers, the flip side is the checks and balances that Ediba. Checks and balances, can we government in secondary school train the constitutionalism. So that because constitution create organs or institutions, as such institutions with authority, as actually how to exercise that authority. You cannot deviate from that authority. You cannot move away from the performance of that responsibility or function outside the procedure that has been spelled out by the Constitution. And so, clearly, separation of powers, checks and balance. Even just look at the ministerial appointments.
Baba na umwaye hakakra. Sa ayi asema na ayi Attorney General ka say the article and a bare rate of summons, statement of case attached to it. No, so we be sanity. I feel too was say release a war panel. The plaintiff has not filed an application for interlocutory injunction seeking to restrain the speaker from proceeding with the vetting and approval of names of the persons submitted by His Excellency the President. Sanity, one application be for interlocutory injunction.
But say a sample, is it within the purview of the Attorney General to pronounce on the competence of the writ? One year poor, is it Attorney General Bakasa, your court? And Attorney General is part of the court.
I see.
So the person to pronounce on the competence or otherwise of a process of court. A court, no? Or a judge sitting, a judge of the High Court. In this particular case, in the Supreme Court, now pronounce on the competence or otherwise of the process filed by the Sierra Court.
Oh, okay. It lies in the bosom of the Supreme Court.
Yes, to pronounce on the competence. Okay, say in the fast track High Court, and Nana Kufado can not Attorney General, no?
Sure.
Or file a case against Chachikata. Or title the case is written
the President and
a title is a criminal summons as in the fast track High Court. Before all years, lawyers in the Attorney General's Department can say, oh, there is no fast track High Court. There's a High Court by fast track division. Or say, no, there's a fast track High Court. What do you call a court? No? The court is a pronounce on the competence of this criminal summons.
Okay.
Because in here, no Attorney General. Yes, people drew his attention to the fact that the Omoye Juma won the office, no. They drew his attention to the fact that you need fast track High Court, but there was High Court fast track division. Was it Debbie? Or the court, the court threw it away, said that the criminal summons was incompetent. So it is the court that will pronounce on the competence or otherwise. Godfrey Dame, with the greatest respect to him.
I see. Enti when na yenyama na baso betimi avet o mind to it. Say anything.
Oh yeah, man. Even let's not over concentrate on what the firm of has done in court, but to see what is happening now as a demonstration of the absurdity of the letter written by Asante Bediatio. Say, in our kind of democracy, which even allows the president to select some of his ministers from parliament, it means that there must be cooperation between the various arms of government. Now, what the president has done is to show gross disrespect to parliament. And parliament is flexing its muscle.
Why Antina show this respect?
Parliament are passing law. Law no, pass a bill. Constitution no in Article 1067. See, say you pass a bill no. One parliament, parliament will present the bill to the president for assent. Now, president and China was thinking say on sign a bill no. Go back up. On China was say on sign a bill no. He can assent to the bill or he can assent to the bill or not assent to the bill. So on yes or 7 days not to do that, or to do that or not to do that. Now where does it lie with the president to direct his executive secretary to refuse to accept the bill, and also warn the executive secretary to cease and desist from transmitting the bill? I mean, that is quite shocking and dictatorial. So when you do that to Parliament, you are treating Parliament with contempt. So I was not surprised that Speaker Backman you see the word contempt.
But maybe what Parliament again said they should hasten slowly because of the pendency of a suit a Supreme Court.
I thought that you would have said they should hasten slowly because there's a decision of the court. But the pendency of a suit. One to say they had two schools of thought.
Sure.
So I thought that you would have said, hasten slowly because a decision has been made by the court injuncting me or injuncting you or injuncting the whole process.
But once an action has been commenced, court, no, injunctive process biya.
Injunctive process biya.
Okay.
Once an action has been commenced in court, an action in court is not an injunction. But out of respect for the court and the court processes, no, there is this growing body of opinion. Say, Basa, don't take any further step that might create irreparable damage. Hold the balance in the interest of justice and fairness, but not by any judicial pronouncement. So, any injunction. In fact, there is another equally strong body of opinion. Say, the only time that you can be prevented from doing something is when a court says so. Okay? If a court doesn't say so, there's nothing restraining you from carrying out your responsibility. There's a further body of opinion who says that it is very unlikely in the absence of demonstrable evidence of non-compliance of procedure by a public official in the performance of his or her functions for a court to injunct the public officer who is performing those functions. Say what he radio see, if it were a public office, according to the dictates of the law. Law so I said the obey way you who the law no so now we hear you. Can anybody go to court and say that you person what you Is it possible? So there's another body of opinion which questions actually bringing actions to restrain, for instance, say then the Electoral Commission conducted 2024 elections. Then Omar be registered and everything. Then 1 week to the elections and 1 month to the elections. So be a motion in court. I mean, suit in court say Electoral Commission. I did the Omo on Tiafe na the confusion by Ghana and Jessica Bio and Ghana and all those things. Or pray court injuncted the Electoral Commission from the performance of the functions. Or in the writ of summons and statement of case, or in the writ any statement of case. Can we lawfully say, properly say, the written almost serve on the Electoral Commissioner. The Electoral Commission should not carry out the elections. Can we lawfully say that? Can we say that?
Hey. Okay, so you better 2024 elections. Yes, okay, obi the court, Supreme Court to injunct the process into about 1 year to. Sir, dear Abbey, this let me call it this legal impasse as a D&D. How do you cure it?
I think that to cure it, there are many ways. I've always said that in constitutional democracy, there are backroom channels for engagement. In the face of demonstrable exercise of power by the various arms of government, Council of State, Peace Council, and all those things should look at the backroom channels. See, how do we resolve this impasse? For instance, yesterday I was telling you, so here, your constitutional arrangement now. Now adding up the days, without even writing the letter that Vidya Chu wrote. Oman Penin Nana Adonako Akufado, in connection with the Human Sexual Rights and Family Values Bill, had 51 days available to him to do nothing. And I want to say 51 days. 7 days to indicate Obasane and Onsane. 14 days. So Onsane, I didn't know Onsane. Part of the 14 days, 14 days, the part of the reasons the overture was a memorandum, could include referring the matter to Council of State under Article 90. Say, Article 90 gives the Council of State in normal bills, again bills, normal bills, 30 days to bring a report.
Mm-hmm.
So what the Nina Kawa, only 51 days free.
Almost 2 months.
Almost 2 months.
So for working days, crowd, yeah, a year.
So it was needless. It was needless. So for me, there are many ways you can resolve this matter. This matter, the transmission of the Human Sexual Rights and Family Values Bill, could go unnoticed if the president had just relied on the provisions of the Constitution. And this you see, so I think that people, the Council of State, Council of Peace Council, and the people of this country, I mean, some opinion leaders and all, must try to exploit the backdoor channel and see. Because Parliament has an agent Sinidai. The one who has the right to recall Parliament is the Speaker. Mm-hmm. In the absence of the Speaker recalling Parliament, just the caucus or members of Parliament sign a petition calling for the recall of Parliament, and with an agenda, recall of Parliament.
Mm-hmm.
And that agenda will have to be debated, and if it is found to be appropriate, then the Parliament will be recalled. So it's a procedure.
Wow.
It's a procedure. But now Parliament has an agent Sinidi. The person who attends Parliament Sinidi has taken umbrage with Adedia Oman Penyin and Nakufado. Oman the secretary.
Now, it's not as a right honorable speaker, and so I take his sides with the issue. Say one approve ya now one sign way or one of your fees are not beauty, sir. Anyway, so yeah.
No, sad Brenner speaker take it. The speaker has taken the side of Parliament. Yes, sir. Because you saw the man hours, resources, time, energy that was used in considering the Human Sexual Values and Family Bill, Human Sexual Rights and Family Values Bill. You saw that. I mean, yeah, even a conference called stakeholders and all those things. You know, at the Parliament for close to 3 months or more. So the debate that is generated in the whole country and the partisanship that characterized the debate. And with all that, Parliament was able to steer its way with all the compromises that they made on the bill in Parliament and passed the bill. Now, why would the President treat Parliament with such contempt? And then you are finding that it's gradually emerging into a pattern. If it's a pattern, then this conduct is not out of the blue, is it?
Mm-hmm. No.
No. So why do you think Parliament will not take offense?
I see.
OKFM.
I see.
101.
But there have been other bills which was not assented to by the president. Mosadi by Parliament. No, sir. No. Ankoso any stare like this one. Ekosi.
On one farm by Parliament, there is no procedure for returning such bills to Parliament, except where the president says object on the basis of certain provisions in the Constitution.
Oh, okay.
The president said he couldn't assent because he saw the unconstitutionality of those bills.
Mm-hmm.
Okay. Now, okay, the response of the speaker that it doesn't lie with the president to determine the constitutionality or otherwise of those bills. Okay. The only time in living memory, and particularly under the Fourth Republic, that a bill has been returned to Parliament triggered by Article 106 of the Constitution, President Kufuor all the time.
Mm-hmm. Mm-hmm.
This domestic violence bill, no?
Yes. And I'm saying about
which one?
Mekai.
Okay, Mekai domestic bill, because I was particularly personally involved. And the third time we called Parliament. And Obi Adapa was the gender committee chairperson. And there was a provision in the domestic violence bill that Ghanaians christened marital rape. And President Kufuor has said that or objected to the inclusion of that clause in the bill. One suggested amendment, but the memo HSA objected to the inclusion of that clause in the bill. And so he returned the bill to Parliament. And the speaker then began to use the referee bill, Emma Committee on Gender, Joint Committee on Gender and Constitutional, Legal and Parliamentary Affairs. They were just meeting in the lobby. That was the time I came to Parliament. I had no committee, and I was passing by, and then Esther Obenha Dapa herself invited me. Say, lawyer, President Kufuor say one sign you, and the boy, then never yeah. And I can tell you on authority that we filed bill, no. Maybe because I was fresh from the courts, but now my man was still like a lawyer, now not a legislator. So immediately I took the bill, I invoked the notion of invocation of conjugal rights under common law, married it with the gender activist position, looked at the provision, juggled the words, placed the words, changed the placements of the words. And when the whole committee read what I had presented, they were satisfied. They thought that was the answer. Fortunately, President Kufuor agreed with the way we formulated the clause and signed the bill. So it happens. And no one, today people don't even remember. So you see how President Kufuor lowered the temperature. See how he lowered the temperature. There's a way to do, there's a good way to do things. So, and I put the blame at the doorstep of the executive secretary. People say that your president is arrogant, is intolerant, is intransigent, is so and so. As an officer serving your president, you have a duty to protect him, also to help him, to help to project him in good light. Even if your president has said you write it in this way, it's your duty to try to convince your president that there's another way that you can write it. But don't do that and add the last paragraph. That is almost a threat.
I see. Honorable, anyway, my minja on a shania a becona way, sir. I yet tussle beer and WM disturb and pa near baby a beco.
Okay.
Medasipa. There's a farms to say.
Oh, and so Yentoy, there you would say you would dry season.
Okay.
So see how they work. I'm also chilling in Accra.
I like that, Alaji.
Okay, that's okay.
Bye-bye, Alaji.
Bye-bye.
Honorable Alaji Inusah Fuseini, a former MP for Tamale Central, and I know
OKFM 101.7.